Holy cow. Welcome in, Bishop on Air. Question to one of the commenters early in the chat. Any update on the MAG case? Just to let you know, no update on the MAG case, but we got updates in the other Southern Districts of Illinois federal cases, including the FFL and their amended complaint. We'll get to that coming up. Also, we'll do highlights from yesterday's first public hearing in the gun and magazine ban registration that Illinois State Police held. A lot of interesting questions. We'll get to those, some highlights. But don't forget, you've got a second hearing happening today in Chicago. I just got off the phone with Todd Vandermeide. He's driving on his way there to provide public testimony on the issue. So we'll likely hear from him as well later on today with that hearing in Chicago. So it's going to be a lot of focus on the latest developments on the state's gun and magazine ban here with Bishop on Air. All right, stay tuned. Plenty more to get to. All right. Like, subscribe, notify, follow, do whatever you got to do. All right. It's Bishop on Air. Hey.
So I hate that mainstream media are picking up right-wing media talking points, so let me correct you a little bit. Yeah, there are 2.4 million FOID card holders in the state of Illinois. 2.4 million people do not have assault weapons. So when you talk about the percentage of people who are filing and registering, it's a much higher percentage than what you've cited of the people who are required to do so.
That's Governor J.B. Pritzker yesterday being asked up in Lake Forest, apparently, about the statistics that we've been reporting here week after week about the gun ban registry. And after a full month, just 0.1%. So not even a full half of a percentage point, just 0.1% of total firearm owner identification card holders letting Illinois State Police know that they have a banned firearm. And that's just the statistic. And while obviously not all FOID card holders have a banned firearm, attachment, or ammunition, it's still, if you look at some kind of benchmark to see a compliance, they say they're a gun owner. That means that just 0.1%, around 2,400 of the 2.4 million, have told state police that they have a banned firearm. We'll get to the latest here on, of course, the gun ban registry hearing that happened in Springfield yesterday. You've got some interesting questions that were popping out and interesting responses as well, but a lot of the responses seem to be just focused on the frequently asked questions that Illinois State Police have on their website. But I wanted to get to the latest litigation against the state's gun and magazine ban because it's pretty crucial. The federal firearms licensees of Illinois, they did file their amended complaint yesterday, and part of that, we'll delve it deeper into it, says, thus to the extent it does not require an entire registration scheme to be enjoined, this court should at least enjoin enforcement of the January 1st, 2023 cutoff date. I think that's a typo. It should be 2024 cutoff date as applied to those firearms for effectively unlawfully banning protected arms. Otherwise, countless people who lawfully purchased firearms will be turned into criminals overnight at the end of the year or forced to forfeit their firearms. The state cannot meet its burden to defend such outcomes under Bruin. So that's the latest from the federal firearms licensees of Illinois. Let's go ahead and take a look even deeper into just the back and forth. Yesterday, as you saw, we reported that the state responded to a request for a amendment, and they ultimately said that they're going to move forward with this with as soon as possible, FFL filing their amended complaint, and then they'll have until December 1st to actually respond, the state said. So yesterday, Judge Stephen McGlynn in the Southern District granted the motion to amend the complaint. So federal firearms licensees of Illinois did indeed yesterday file that amended complaint. So let's go ahead and pull that up here. So we'll take a look at the amended complaint in some detail. But if you go through, you'll read that says, while tensions have been building for some time, they go into historical record and some writings that happened way back when in the understanding of the Second Amendment. And they go back to even April 18th of 1775. They say the fighting started in earnest when hundreds of British troops marched from Boston to nearby Concord in order to seize arms that were in a cache. And they go on to say, despite being overwhelmingly outnumbered and outgunned by colonial farmers and everyday citizens mobilized as quickly as they could, bringing their private arms to bear and in the defense of individual freedoms, a free state. By the end of the day, these common everyday citizens succeeded in driving the British all the way back to Boston and inflicting more casualties on the redcoats they themselves had suffered. In other words, free persons exercising their pre-existing natural right to keep and bear arms had successfully driven back the preeminent superpower of their time. And I think that's a really fascinating argument they lay out, going back just to highlight the purpose for the Second Amendment. And they go through and spell out a variety of other things in their amended complaint, saying because it's clear that the firearms and ratifiers of the 14th Amendment and the framers of the 14th Amendment, they counted the rights to keep and bear arms among those fundamental rights necessary to our system of ordered liberty. The Second Amendment right to keep and bear arms is incorporated into the Due Process Clause of the 14th Amendment and may not be infringed by state or local governments. Courts may not apply a means and interest balance test akin to intermediate scrutiny in Second Amendment cases, they say, pointing to Bruin, the U.S. Supreme Court's ruling last summer. They go on to say that semi-automatic rifles, include ones now banned in Illinois, traditionally have been widely accepted as lawful possession, as well as semi-automatic shotguns and handguns. Our historical tradition also makes clear that the Second Amendment exists to guarantee an armed citizenry who can act as a bulwark against tyranny, whether from a foreign invader or a domestic government that disrupts our constitutional republic or violates the individual rights it's sworn to uphold. So then it goes into a bunch of other historical quotes, and we'll just scan through here to see some of these that they pulled up in the actual amended complaint. And these are, again, just some of the things that they've already highlighted. And you can see, they're adding writings from 1861 and 1868 and the reasons why to keep and bear arms from a book in 1880 and 1898. So they really go into depth as to what exactly they're looking at here. But I think also it's important that we look at some of the other arguments they've made, especially when it comes to the registry, because that's the crux here. All right, as I said at the top, they ultimately are looking to have the registry blocked entirely. If not blocked entirely, then at least that January 1st, 2024 deadline to be postponed. So if you look at page 23, it talks about how while existing owners of newly prohibited firearms have a window of time to register their firearms, which will be grandfathered in with the owners allowed to keep their firearms, the registration of firearms is unconstitutional as it is completely without any backing in our nation's historical tradition of firearm regulation. As history has taught all too often, registration always and everywhere eventually leads to effective, if not actual, confiscation, as occurred in the city of Chicago decades ago. No other constitutional right works in this way. Plaintiffs deserve to be able to continue to possess their lawfully acquired yet now restricted firearms without registering them with the state police. They go on to say that in the emergency rules, which are up for consideration, as you had the public hearing yesterday and another public hearing today and another one down in Caseyville for Monday morning, they're all about these emergency rules for the gun ban registry. And this is, again, something that opened up October 1st. You've got a January 1st deadline, or you could face criminal penalties. Obviously, there's a lot of concern out there. But it goes on to say emergency rules only allow where there's a threat to the public interest. And I think that's interesting. They highlight that, there's not really a threat to the public interest, they say. But they go on to discuss that they're talking about the safety and welfare of the public, which requires rules to be adopted in a less time frame than would typically be allowed. Why the state police waited over 9 months from when the firearms were actually banned. We'll scroll down to get to this. It's rather a fascinating argument. These emergency rules took effect immediately. So why the Illinois State Police waited over 9 months from when the Firearms Ban Act was adopted to file those emergency rules rather than making proposed rules under the normal process, it's not explained. Thus, they say, to the extent it does not enjoin the entire registration scheme, this court should at least, in the Southern District of Illinois, right, while they're still dealing with the Second Amendment arguments up in the Seventh Circuit's Court of Appeals, down in the Southern District, they brought the case back to say, we're wanting to challenge the registration now on the basis of violating the Second Amendment and 14th Amendment. There hasn't been an argument of the Fifth Amendment made here yet, and that's the one against self-incrimination, but the 14th Amendment really is all about like due process and a whole host of other things. Anyways, they go on to say, thus, to the extent that it does not enjoin the entire registration scheme, this court in the Southern District should at least enjoin enforcement of the January 1st cutoff date as applied to those firearms for effectively unlawfully banning protected arms. Otherwise, countless people who lawfully purchased firearms will be turned into criminals overnight at the end of the year or forced to forfeit their firearms. The state cannot meet its burden to defend such an outcome under Bruin. Goes on to say that there's been no due process. Yet, Illinois has not provided owners of impacted firearms actual notice of the registration requirement. To plaintiffs' knowledge, the only notice that FFL says in their amended complaints that Illinois provided to the public is the registration requirements, posting announcements about it online. Which you got to think that's not necessarily the best way to go about informing people who, are typically waiting for some kind of notification from the mail, right? So it says, yet Illinois has not provided owners of impacted firearms actual notice of the registration requirement. To plaintiffs' knowledge, the only notice that Illinois has provided to the public about the registration requirement is posting announcements about it online. That's insufficient, particularly for a law that prescribes serious criminal consequences for failing to take steps presently for previously completed transactions that were lawful at the time. If retroactive laws change the legal consequence of transactions long closed, the change can destroy the reasonable certainty and security, which are the very objects of property ownership. Goes on to say, Illinois could have easily provided direct notice to the registration requirement to all FOID card holders. Why? Well, because they have their contact information. If you have a firearm owner identification card, they know your address. Several years ago, my FOID card was jeopardized because Secretary of State misspelled my driver's license on my driver's license, the physical ID. And then when ISP was, doing checks as they do with FOID cards regularly, apparently what I had on my FOID card didn't match the street address of my driver's license. So they sent me a note and said, hey, your FOID card, if you don't rectify this, it's going to be ineligible. It's going to be void. And I was like, whoa. So I had to get Secretary of State Police to correct one letter in the street name on my ID that they messed up. It was like a D to a B. They needed to change it back to a D. So that one thing, I got a notification in the mail about that, but I have yet to get anything in the mail about this, especially it being, if you don't register, you could be a potential Class A misdemeanor or Class 3 felony for a second offense. But Illinois could have easily provided direct notice to FOID card holders because, well, they have their information. Goes on to say that, finally, even if actual notice is not required to meet due process mandates, posting emergency regulations online, triggering a 3-month window for effective individuals to learn about it and comply with it is insufficient notice, temporarily speaking. In sum, they say Illinois has failed to provide sufficient notice to those subject to the registration requirements, which is reason enough for this court to immediately enjoin it, at least until sufficient notice can be provided. So that's the kind of summation there of the Federal Firearms Licensees of Illinois' amended complaint in the Southern District. So again, to recap, all right, I know there's a lot there. Nothing yet from the Seventh Circuit U.S. Court of Appeals. Still waiting on something. However, there was a filing that the state did make in the Seventh Circuit Court of Appeals. If you recall, we've talked a lot about these supplemental authorities that have been filed. And the plaintiffs have filed several supplemental authorities in the Seventh Circuit U.S. Court of Appeals saying, hey, look at Hawaii's butterfly knife ban that was struck down. Hey, look at California's magazine ban that was struck down. Hey, look at California's firearms ban that was struck down. Hey, look at Texas's, I believe it was the pistol grip rule or one of the other rules. They point to these other rulings and say you guys should take these into account. Well, several times also you have the state responding saying, well, the appeals court put a stay on the magazine ban, for instance. Well, the most recent filing from the state, it points to the Miller v. Bonta case, because the plaintiffs said, again, they pointed to the Seventh Circuit and said, look at over the Southern District of California, which enjoined enforcement of California's restriction on, quote, assault weapons, as set forth in California Penal Code section goes on. But the Ninth Circuit, the state says, has already stayed that decision, which conflicts with the vast majority of decisions address a challenge of the law restricting assault weapons from New York State Rifle Association v. Bruin. And it gives a whole list of other cases where such decisions have gone in favor of certain types of bans. So, again, you've got the state in the Seventh Circuit Court of Appeals filing that response to a supplemental authority that plaintiffs filed. So that's still happening in the Southern District. No ruling from those judges in the Southern District about the Second Amendment. But you still have, in the Southern District, two cases. One from Thomas Magg, challenging the vagueness of the registry, challenging the vagueness of the law. That's still pending. They heard that in court last month. So we're still waiting on a ruling from Stephen McGlynn, the judge in the Southern District, on that particular issue. All right? So we've still got that pending in the Southern District. Now we have the federal firearms licensees of Illinois and others, Gun Save Life being included in that plaintiff's group, as well as others. They have now filed and been granted an amended complaint, which says that the registry needs to be halted or at least delayed until proper notification can be granted. And they give out a whole list of reasons why the registry is improper and it violates due process in their arguments. So now Stephen McGlynn is going to be setting out a schedule for that particular argument. So here's the question that's going to be interesting. How indeed they're able to get the briefing schedule in to have the state respond. I think by December 1st is what they say. They've agreed with the plaintiffs to respond to the plaintiff's amended motion. Are we going to see maybe 2 weeks after that a hearing? And then what? A week after that? It's close to the end of the year. Is Stephen McGlynn going to come through and provide a preliminary injunction to halt the implementation of the registry deadline before the end of the year? Seems that the balls are up in the air, and you're going to have briefs, so there's going to be plenty for us to unpack in the days and weeks ahead. So that's the latest in at least what's happened in the past 24 to 48 hours in the Southern District of Illinois, challenging Illinois' gun and magazine ban, while we're all still waiting for whatever happens out of the Seventh Circuit U.S. Court of Appeals. Oh, boy, there's been a lot there. I appreciate everybody tuning in, as always, and you can find me anywhere. Just search Bishop On Air, and we can connect on YouTube, on Twitter, on Facebook. So just find me, and let's make it happen, all right? Stay tuned. We've got tons more coming up, including a review of yesterday's first public hearing concerning the gun ban registry with Illinois State Police. Yesterday was the first public hearing with Illinois State Police in Springfield about the state's gun ban registry. And while it wasn't a packed house, there were plenty of firearms owners there asking questions. Were they getting much of a response? Let's go ahead and get right on into it. I was there and obviously covering it for thecentersquare.com, where you can watch today's proceedings up in Chicago live. And I promise the audio will be much better. The room they had in Springfield, we'd known was going to be a problem for a variety of reasons, not just the size of it, but you've got questions about media hookups and just the audio quality was expected to not be that well. So eventually it did get worked out, but you can see that still at thecentersquare.com and watch all, 90 minutes of it. But today you're going to have the second hearing up in Chicago, again, at thecentersquare.com/Illinois. You'll be able to see the live link there, and you can watch live at 9:30 this morning. Todd Vandermeide, Freedom Steel, expected to testify. I imagine you'll have a whole host of others testify. It'll be interesting as well to see if there are gun control advocates there to testify on behalf of the Protect Illinois Communities Act. But let's go ahead and get into yesterday's hearing in Springfield, some highlights. Suzanne Bond, she's the Illinois State Police Special Counsel. She was the one fielding the questions and helping kind of facilitate the public hearing. And she laid out some of the things that the public hearing's really going to be focused on.
ISP has developed and implemented a public notice and public outreach campaign to promote awareness about the provisions of the Act and published several different resources on its website to help people understand and comply with the Act. For example, our website has links to the Act, ISP's proposed rules, a PICA identification guide, as well as FAQs. Additionally, ISP has posted routinely on its social media channels about the requirements under the Act and produced a tutorial video to help guide the public when disclosing assault weapons, assault weapon attachments, 50 caliber rifles, and 50 caliber BMG cartridges as defined by PICA. The PICA identification guide is intended to assist Illinois residents with determining whether they have an assault weapon regulated by the Act. To the extent they do, we remind them to use our website to submit their electronic endorsement affidavits prior to January 1st, 2024. The FAQs are intended to provide additional guidance to ensure Illinois residents can comply with PICA. ISP has made every endeavor to ensure our administrative rules are within the authority set forth in the statute by the legislature. These hearings are held to gather your questions and ensure we have addressed them within the limits of our authority before we move to second notice in the Joint Committee on Administrative Rules process.
So that second notice is interesting because, of course, you've got the Joint Committee on Administrative Rules. They're set to meet again in December. And whether or not the questions are going to be answered in an appropriate manner, still up in the air. And while you've got the Southern District of Illinois courts still dealing with the question of whether or not to delay implementation of the January 1st deadline, JCAR could suspend the emergency rules. So they could still do that in December. But will all the answers be had before that December JCAR hearing? JCAR set to meet next week, so we'll see what happens. And as far as these rules, they could possibly make another motion to suspend the rules, which would suspend implementation. But we'll watch that closely and update you as that happens. But they've also got a hearing that they'll have in December, and whether or not all of these answers will be made before December, it's a big question. They say, well, then by January, but that would be after the January 1st deadline. And if there's still substantial questions out there, how are you going to be able to answer all of those? So they then began reading some of the public questions, and these were ones that were submitted, not from people who were physically there. These were public questions that were submitted to Illinois State Police, and they read those verbatim into the record, but it really kind of played out in at least one example. Here's how some of that played out.
The shell links that are in common use and availability are 1.75 inch, 2.75 inch, 3 inch, and 3.5 inch. Which should a gun owner use to figure out his shotgun's magazine capacity?
Shotgun shells are not regulated by PICA. Please refer to the Wildlife Code for this question.
And you can see people in the audience kind of shaking their heads because they just didn't really feel like that was the appropriate answer to actually provide some clarity on all of this, because there's still plenty of questions. Other pointed questions from yesterday are being read into the record and responded to.
What is the policy of the state police with regard to the 99.9% of owners of PICA categorized firearms who have historically been fully compliant with firearm laws that simply didn't capitulate to a registration which they are reasonably likely to be unaware of?
Again, answers to this question can be found on ISP website, on the Protect Illinois Communities Act, and we would again refer you to FAQ number 16, which I just read.
So, point back to the FAQ. What about federal laws?
8. Please describe how the registration above is compliant with Title 18 U.S. Code of the Firearm Owners Protection Act of 1986.
Again, answers to this question can be found on the ISP website on the Protect Illinois Communities Act page, specifically see FAQ number 33. How is the Firearm Owners Protection Act of 1986, 18 U.S.C. Section 926 relevant to the ISP rulemaking under PICA? The answer is it isn't. 18 U.S.C. Section 928 applies to the Attorney General of the United States and sets forth what rules and regulations a federal agency may create to regulate firearms. The authority for the PICA and the endorsement affidavit is based upon the statute passed by the Illinois legislature and is not a rule or regulation created by a federal agency. See National Shooting Sports Foundation Incorporated versus Jones, 405 U.S. Appellate D.C. 18, citing RSM Incorporated versus Buckles. Rejecting argument because Section 923G5A is a statute, not a rule or regulation.
So again, just some of the questions being asked publicly from those who wrote questions in, but there were others who decided to show up in person and provide questions and demand answers, including State Representative Brad Halbrook with the Illinois Freedom Caucus.
I want to be clear that we know this public hearing is taking place because the governor and his radical left agenda. He and his Democrat legislators passed this bill and then laid it at your feet to have to deal with it. I support law enforcement unapologetically, and we know this is not your fault. However, there are questions that need to be answered. I understand that you may not be able to answer these questions for mine and others. However, we have an expectation to get those answers in a reasonable length of time. What is the reasonable length of time that we should expect those answers, and in what manner or form will they come in?
We are in receipt of questions from JCAR, and we are also in receipt of questions coming in through our public comment portal, and we are going to endeavor to have answers to those questions before the JCAR December meeting. Hopefully that will be possible. If not, it will definitely be in January, but our goal is to answer them by December.
So just to be clear, going into the JCAR meeting in December, we will get those answers back email, they'll be on the website. How will we know that we'll have answers to that going into the JCAR meeting?
Well, we will at least respond to the people that submitted the questions, but I believe we will likely put many of those answers on our website as well.
Okay. So here's the questions I have for you today. What happens when hundreds of thousands of gun owners are non-compliant overnight and they're just otherwise totally law-abiding citizens? What is going to be their punishment for non-compliance?
And you can see the ISP counsel not really responding right away. She was taking down some notes and then realized that Halbrook was awaiting a response.
Sir, my intent is to take down your questions and provide.
Okay, I mean, I can submit these later in writing so that we don't, I'm looking for a response.
Okay, so my initial response would be that we will turn to the bill, and I believe the bill sets forth penalties for failure to file your endorsement affidavit, and so it will be up to each individual state's attorney in the 102 counties to decide how they will enforce that.
Yeah, so the question remains, what are the penalties?
We'll look it up. Okay, I'll look it up.
Halbrook continues on.
How will this registry be
questions.
used as a source to later seize firearms from individuals?
The Illinois State Police is not aware of any intent to do so.
So again, the questions continued on. Halbrook provided even more questions about gun confiscation, about the constitutionality, about what happens if indeed this gets struck down.
The legislation is still under a legal challenge, as it is in or other similar legislation in other states. What happens if it is declared unconstitutional and someone has already been punished?
Well, I think that will depend upon the state's attorney of the county and the courts in those counties and how they handle that. Those issues won't be up for the Illinois State Police to decide.
People couldn't hear her.
I said I don't believe those things will be up for the Illinois State Police to decide. I think that will be up to the state's attorneys and the courts of the various counties throughout the state of Illinois.
Also, if this is overturned, will the registry be destroyed?
I can't answer that. I don't know the answer to that. I mean, I would assume that if the law is ruled unconstitutional, we would be directed by a court on how to handle that.
Will the confiscated weapons be returned?
If the law is ruled unconstitutional and a weapon has been confiscated, I would think that the law enforcement would be required to return it. But again, those are not things that will be decided by the state police unless we have confiscated the firearm.
So I guess that's the question when it gets back to the enforcement and things like that that's being discussed today.
It's interesting she keeps referring to state's attorneys that are going to be responsible for enforcing this, unless the Illinois State Police are the ones that are confiscating the firearms. And, the question about if they're confiscated and shot down, who gets those back? It's up to the state's attorneys. We've seen a lot of state's attorneys and even sheriffs across the state say that they are not going to enforce this. They see this as an unconstitutional law. Halbrook was wrapping up his comments, but then you had, again, Suzanne Bond, the ISP counsel, fielding these questions, getting back to him on the issue of what the penalties are.
Sir, I wasn't trying to put you off. In response to your question about the penalties, it is on FAQ number 15, and the first offense for failure to file an endorsement affidavit is a Class A misdemeanor.
And then Halbrook had further questions about, well, what about subsequent offenses? You've got Class A misdemeanor for the first. What about the second and third and fourth?
And then the next step is what? Let's go through the progression.
The first offense is a Class A. Second and subsequences are Class 3 felonies.
So again, the question is, what is the definition of first offense and subsequent offenses after that?
Okay, again, that's going to be up to the state's attorney and the courts, but typically that would mean that you have to have a conviction for the first offense before it would move on to a second offense.
So there you go. Again, she says that it's going to be up to the local state's attorneys and the courts as to how that all plays out. So that was Halbrook's line of questions. You then had Josh Witowski from Illinois Federation for Outdoor Resources. He was there asking a whole host of questions about different types of shotguns, especially shotguns that have magazines where, a certain size of a shotgun shell may take up 5 slots in that magazine, but then if you get a reduced size that still goes into the same caliber of shotgun, then you can have, 7, 8, 9 shells in there. And that raises the question if that particular magazine and that shotgun is an extended magazine. You've got other questions as well, including this rather fascinating question that Witowski raises.
Are you familiar with airsoft?
Yes, I am.
Small plastic pellet firearms. They use the same attachment points that modern sporting rifles use. So, if an individual only possesses airsoft rifles and has a forward grip for their airsoft rifle, do they have to register that forward grip as an assault weapons attachment? Because it could be attached as a second grip onto a modern sporting rifle.
It would not be our understanding that it needs to be endorsed. However, that is an issue for all 102 counties to decide how they will enforce, and I cannot tell you how they will or won't enforce that.
So again, leaving it up to the counties on local prosecutors and how they're going to actually deal with these things. Witowski had other questions and demands at yesterday's hearing.
To us, this violates the legislative intent that was expressed during debate, because it was said during debate and during negotiations on this legislation that the Illinois State Police and Illinois Department of Natural Resources were going to develop a list of firearms for sporting purposes that were supposed to be submitted. And in fact, the Public Act even has this listed under Section 4 of exemptions. We are asking that Appendix B be modified to be a specific list of firearms with sporting purposes that are not required to be registered under this act. And I will submit the rest of it in writing because there is still quite a bit to go.
So obviously a lot of things
on the issue that you raised.
Yeah, a lot of things being submitted in writing from yesterday's public hearing. I imagine even more things will be submitted in writing after today's public hearing and even after Monday's public hearing down in Caseyville. But you had others who were there yesterday, including Jacob Caveney from Carlinville, and he had some questions as well. He talked about, the difference between certain types of firearm magazines that if it's, 223, it would have 30 rounds, but if it was a different caliber, then it would only have 10 rounds and works in the same magazine. So what about that? And time and again, the answers and the responses from the state police were either A, refer back to the rules, or B, please submit your questions in writing and we'll get you a response. So Jake McCaveney, he had other questions he had proposed to state police to try to get some answers.
Are FFLs exempt from the inventory from registering weapons?
The endorsement affidavit provisions are applicable to people. So if an individual is an FFL and not a business, then they would be subject to the endorsement affidavit provisions. There is no exemption specifically for an FFL in the Act.
If FFL does business as, or their FFL is under a business, they would be exempt, is what you're saying?
The endorsement affidavit provisions state that they are for a person, not a business.
Didn't the Supreme Court justify or recognize that businesses are people?
Businesses are welcome to comply with the endorsement affidavit provisions if they would like to. There is no prohibition on a business doing it, so if a business owner would be more comfortable doing an endorsement affidavit, they are welcome to do so. Our interpretation is that the endorsement affidavit provisions were intended for people, not businesses.
So some interesting questions there from Caveney, and he closes.
The last remark I'd have to say is thanks to Bishop and Todd Vandermine for keeping Illinois gun owners semi-up-to-date and raising valuable questions on the matter.
Didn't need the shout-outs, but I do appreciate people recognizing the hard work and keeping people posted day in, day out on these issues, because it is fast-moving and no question only going to get quicker and as far as rapidly approaching that January 1st deadline. So a lot of litigation still to happen, a lot of questions still to have as well, including you had another individual from Hudson, Illinois, Greg Magnuson. He testified and said that he moved out of states, came back to the states after California did a whole bunch of things that were infringing upon liberties, and now here he is back in Illinois thinking he was safe, but wakes up to find out that commonly owned firearms are banned in the state of Illinois and that he's going to have to register them or face criminal penalties, and he had a pretty impassioned speech.
This law ignores daily gun violence that can be located easily on a map. To pander to people convinced by TV and Democrat leaders that every gun owner in America is a terrorist. I'd like to stay, but I really think my pleas here will be not even considered, and I have little faith that the court will stop this bill's implementation. And perhaps this is inconsequential to you here, but this is for the Democrats not here. I didn't know what to expect. This is my first time I've ever done this, okay? I thought maybe a representative would be here, except for this Freedom Caucus guy who actually wants to stand up for the state. This state has unfunded pension liabilities of $211 billion. Massive annual budget deficits, despite the $500 million that they got as a windfall this year. Lost revenue, $2.9 billion annually from the canceled gun industry. Empty office buildings in Chicago. Tens of thousands of residents already escaping the state's oppressive taxes and horrible weather. It would behoove this group to reconsider implementation of this law. I urge you to veto this bill, stop all plans to enforce it before the financial loss incurred by the state is unrecoverable. Thank you.
So, again, that's just some of the public comments. And then they closed it out and moved on. So that was brief highlights from yesterday's public hearing in Springfield. We'll have another public hearing today in Chicago that will be live streamed. Go to thecentersquare.com. Again, thecentersquare.com/Illinois, and you'll find the live stream there right at about 9 o'clock. It goes live at 9:30, so you can make that happen and connect and watch that live. And I think that you've got another hearing that is going to be on Monday morning down in Caseyville. So we'll definitely be highlighting all of these. And Monday morning, we'll tip back into what happened today in Chicago and review some of that. But I was on the ground in Springfield, asked some of the participants there, in particular one citizen from Springfield, Jim Helm. He talked about how he did go and have some questions. He didn't hear his questions being addressed during the hearing, and he did go and get some of those questions answered after the hearing. But he said overall it wasn't necessarily beneficial to all of those who had ongoing concerns.
Most of the people here were looking for simple answers to their questions, and going back and simply referring to the law itself, it would have been nice if they'd have been a little bit better prepared on some of the specifics. They did on some, but not on all.
I also talked with State Representative Wayne Rosenthal, who was there, and he said that the way the answers were provided during the hearing aren't really, again, helping.
You know, the first reaction is going in there. When the first questions got asked and they referred you back to the website, and that's exactly the reason people were there asking these questions, because when they go to the website, they're confused on what the answers ought to be. And so I think they're looking for specific answers, and they're not going to get that here. So there's a lot of confusion out there in the public. And, you know, one of the things I will tell you is that I know that I have constituents that have been hunters all their life, and they would be totally unaware that some of the weapons they have may be considered assault weapons.
Well, I also talked with Amy Ellick, state representative, who, as a measure to ultimately require state police to destroy the gun registry data if the law is struck down. I asked her about the status of that, but really ultimately her reaction to what she heard during the public hearing.
Well, my general takeaway from this hearing today was that the ISP is forced with implementing a vague law that has so many questions left to be answered that they frankly can't answer because it's not in the statute to give them the ability to answer this vague law. So I think that they just keep referring to their website and saying, we'll get back to you. It's disappointing, but I guess I really, I don't blame them for that because this is what they were handed as part of this bad.
And I also asked about the status of her law that she's proposing to require the registry data be destroyed if the law is struck down by the courts, and whether she's getting any traction from Democrats on that proposal.
I don't expect to get traction from the other side on this, and unfortunately I think that this is going to have to be a court order when the law is found unconstitutional. But I wanted to make sure that it was on record because I want people to know, we know that you're going to be having a lot of data, a lot of information on what individual gun owners in Illinois have that they have decided that they feel forced to register, and we're watching to see what you do with that data and information later when this is found unconstitutional.
So clearly, still a lot of questions, a lot of concerns out there. And Governor J.B. Pritzker was at an unrelated event in Lake Forest yesterday, dealing with infrastructure improvements and dealing with flooding. But during the Q&A, he was asked about the gun registry and, in particular, the reporting that we've been doing week after week after week, highlighting how the first week of the gun registry after October 1st, there were only 0.04% of the state's firearm owner identification card holders that told state police they had a firearm. In the second week, it was only 0.07% of the state's FOID card holders that told police that they had a banned firearm. In the third week, it was 0.08% of total FOID card holders that told state police that they had a banned firearm. And after the first full month, it was only 0.1% of the 2.4 million FOID card holders who told state police they had a banned firearm. That's just the math and the statistics. Governor J.B. Pritzker asked about that. He brushed it off as, quote, right-wing talking points.
So I hate that mainstream media are picking up right-wing media talking points, so let me correct you a little bit. Yeah, there are 2.4 million FOID card holders in the state of Illinois. 2.4 million people do not have assault weapons. So when you talk about the percentage of people who are filing and registering, it's a much higher percentage than what you've cited of the people who are required to do so. I can tell you, at least for me, that I think all of us take our time sometimes when we know the deadline is 2.5 months hence, that we'll find the time eventually to go online, which is what they need to do, and to register as they're required to do. So we expect there to be more and more people as we get closer to the deadline, which is the end of the year, to do so. And, people who don't, obviously, at some point, they will be breaking the law.
The governor was also asked about, well, aren't these in common use? That's the argument.
They're not that common, and I should probably ask Representative Morgan, who drafted the bill, and Senator Morrison, who was very instrumental in it, to talk about this. But I will say that the target here is keeping people safe. You should be able and free to go to a parade and not get shot at, and not have 83 bullets fired in 60 seconds or less. And that's all we're asking. We're not taking guns away from people. We're not limiting your freedom. We're simply recognizing that we want people to be safe, and don't think that it's a weapon that keeps you safe to have something that fires that many bullets in that short a period of time. I don't know if Representative Morgan wants to address it as well.
And Representative Morgan was
I would
instrumental
echo
in
everything the
crafting
governor
law.
just mentioned. This is new for the state of Illinois. As you noted, historically, we've registered people with our FOID card registration. This is the first time we're registering weapons themselves. I also think there are a lot of individuals who have these weapons. They're considering whether to sell them to someone out of state, which is a provision in the law that they're allowed to do. So I do think this is a function of cramming for the test, that people will wait till the last minute. They'll see, there's obviously, we're still waiting for a ruling from the Federal Court of Appeals. Some people are waiting for that. But I also expect that number to increase as people recognize that they want to be law-abiding citizens, and they want to be consistent with state law, and they will register their existing legacy weapons. Otherwise, they're risking their FOID card. And I think the vast majority of people are just committed to being law-abiding citizens the way they are now.
So there you go. That's some of the back and forth. We got plenty of questions.
Thank you very much, everybody. It's a great day for Lake Forest.
That's, again, Governor J.B. Pritzker closing that out. So today, another day of public hearings. Second of 3. Go to thecentersquare.com/Illinois to watch along live. We'll have highlights Monday morning here with Bishop on Air. And then you've got another hearing down in Caseyville Monday morning at 9:30. Plus, we've got the court cases we'll continue to monitor, with the FFL of Illinois filing an amended complaint saying that the gun registry needs to be blocked or suspended. You've got the Thomas Mag case still pending with Stephen McGlynn looking to possibly rule on that. We've still got the 7th Circuit Court of Appeals with a pending ruling there. So tons for us to cover here each and every weekday morning with Bishop on Air. I want to thank you guys so much for taking part in the program and tuning in and sharing the word. It really does mean a lot. And I, again, want to thank everyone for, your support. And be sure to, tell your friends. And be back here on Monday morning as we continue to update you on the very latest here in Illinois. Also next week's fall veto session, the final 3 days of legislative session for the calendar year. Things that are unresolved: the Invest in Kids School Choice Scholarship Program, nuclear moratorium, whether or not there are going to be any changes to hold harmless those who bought weapons during a court-ordered injunction. So we'll follow all of that. Have a great weekend. We'll be back at it Monday morning. You guys are still here? Get out of here. What are you doing? The show's over. Sorry, it's my level up. Ferris Bueller reference for the day. Have a great weekend, guys. Happy Friday.